Okay, people are still kind of coming in, but we've gotten what looks like a decent critical mass, so we'll go ahead and get started. I'm really excited today. We have a very special participant that we're very grateful to have here. Corey is a civil rights lawyer who's currently head of special litigation at the Legal Aid Society in New York. Until 2017, she was the senior counsel to the Assistant Attorney General for Civil Rights in the Department of Justice under President Obama. Before that, she was a senior attorney at the ACLU in New York, and she led litigation and advocacy on campaign issues and on campaigns on issues including racial and economic justice, criminal justice reforms, free speech, student rights, immigrants' rights, and religious freedom. She was a clinical adjunct professor of law at NYU and a Fulbright scholar. And, from kind of our insular debate perspective, as at all, she's an alum of Michigan Debate, where she was an incredibly successful policy debater. So she knows kind of what you all are going through and doing. And she's parlayed into a really successful and awesome career as a lawyer. And so, Corey, I'm looking forward to it. Take it away.
Thanks. And thanks everyone to coming to this lecture this morning. Actually, Kevin, before you go, could you remind me, I know that the topic is police reform, but I was actually wondering what the exact framing of the resolution is this year.
Yeah. It was resolved the federal government should enact substantial criminal justice reform in one or more of the following areas: policing, sentencing, and forensic science.
Got it. Right. So this is a lecture that's really going to be focused on the policing end of that trifecta for criminal justice reform. Although I've worked on those other issues as well and work a lot on sentencing reform, especially in New York in my current role. But I think I came here today mostly to talk about policing because when I was in the Obama administration in the Department of Justice and was senior counsel to the Assistant Attorney General for Civil Rights, police reform was really probably our top priority, maybe voting rights, but certainly one of our top few priorities. You might remember, or maybe you don't remember, it's quite a long time ago for you, that in 2015, it was really the rise of the Black Lives, the first rise of the Black Lives Matter movement following the killings of Freddie Gray and Eric Garner and Laquan McDonald and many others, Philando Castile. And police reform was a really big focus in that latter stage of the Obama administration. When we were at the Civil Rights Division, we opened investigations into police departments, really high-profile investigations into police departments in Baltimore, in Chicago, and in Ferguson, Missouri. So I want to talk to you today a bit about those investigations and what a policing investigation by the Department of Justice Civil Rights Division really looks like from the inside, in the hope that that will give you a little bit more context to understand what might be, I assume, a focus of some of the affirmatives that will be run on the police reform side of this year. And then I'll also talk a little bit about other tools of police reform that the Department of Justice has beyond what we call the pattern and practice investigations that are run out of the Civil Rights Division, to give you a little bit of sense of those. I'm going to try to keep this to well under an hour so that there'll be well over half an hour for questions. I've been away from debate a long time, and I know debate, I know when I used to hear from people who debated like 20 years ago, when I was a debater, which is basically what I am to you now, I was always like a little struck by how they didn't really get what debate was really like these days. So I'm very conscious of the fact that I'm not entirely sure what information I have will be useful to you. So my response to that is to try to keep as much time for questions as we can. But let me start a little bit. With a general overview of what a pattern or practice investigation run out of the Civil Rights Division of the Department of Justice looks like. And to understand that tool, I'm sure by now with all your research you have realized a critically important fact about the relationship between the federal government and police reform is that the federal government does not have the power to instruct police departments to instruct or manage the operations of state and local police departments, even when the actions of state and local police departments violate federal law. Just like you or I would have to sue a police department in court to force a police department to comply with the law and change its policies or practices, so must the federal government. There's no, there's no passing a law. It's not self-executing once you pass a law that says it's illegal to, use chokeholds, for example. In order to enforce that, the federal government has no greater tools really at this stage in the game than you or I have as private citizens to compel a police department to comply with the law. And so the Civil Rights Division is the part of the federal government that enforces federal law as applied to state and local police departments. And in particular, they enforce a statutory prohibition on any quote unquote pattern or practice of policing that violates the Constitution or other federal laws. So pattern or practice investigations, as we call them, begin with investigations into systemic problems of police misconduct in police departments. And if the allegations are substantiated at the end of that investigation, end with comprehensive agreements designed to fix the problems that the investigation showed to be the cause of the violation of the pattern or practice that violated the Constitution or federal laws. And these investigations are a vehicle to enforce rights that are defined and protected already by the Constitution or other federal laws, such as the right to be free from excessive force under the Fourth Amendment to the Constitution, or the right to be free from unreasonable stops and searches, also protected by the Fourth Amendment, arrests without warrants or sufficient cause, also protected by the Fourth Amendment, or arrests in retaliation for exercise of free speech rights, whether that's protest or the free speech right to film or record police officers, which is protected by the First Amendment, or discrimination based on factors such as race and ethnicity, national origin, religion, disability, sex, and gender identity, including sexual orientation and LGBT status, which as of actually just a few weeks ago, it's now perfectly clear is prohibited by the law. So pattern or practice cases focus on systemic police misconduct, it's important to understand, rather than isolated instances of wrongdoing by police departments. And they also focus on the responsibilities of law enforcement agencies and local governments rather than on the behavior of individual officers. So that's kind of what a systemic or pattern or practice, what distinguishes that between other tools that we have to go against to enforce against individual officers and their own liability for their own misconduct. Some investigations are comprehensive analyses of the patterns and practices of policing in a particular community. So, for example, our investigations into Baltimore and Chicago were really kind of top to tail looks at what was wrong with policing in those cities. But others have been more narrowly focused on a specific area of policing and practice at a particular place. And I'll give you some examples of that as I get through some of this lecture. If DOJ finds a pattern or practice of police misconduct, then we would issue a public finding saying that in the form of a findings letter or a public letter or report that set forth the conclusions that we came to at the end of an investigation and also all the evidence that supported that conclusion. And then after making those findings, what would typically happen is that we would negotiate reform agreements to resolve the problems we identified. And the nature of those agreements has been the subject of many differences of opinion amongst Democratic and Republican administrations, and I'll discuss that a little bit more in detail as well in a few minutes. If an agreement cannot be negotiated, or if if the local jurisdiction puts up a big fight, then the Civil Rights Division will bring a lawsuit to compel the needed reforms. But that is really rare, largely because most state or local police departments would prefer a negotiated agreement to being sued by the federal government in court. But I'll tell you about a few examples where local governments decided that they would rather fight in court than negotiate an agreement. So that's the broad brush overview. I just wanted to give you a sense of what the picture I'm going to paint is before I started to get into the kind of details of brush strokes. With the rest of this lecture, what I'll do is talk to you a little bit about the history of pattern and practice investigations and the mechanics of them, and then some of the issues and controversies around them, which are kind of my assessment of where maybe some of the debatable propositions when it comes to this tool for federal police reform might exist. And then again, like I said, I'll more briefly talk to you about some of the other tools for police reform beyond pattern and practice investigations that the Department of Justice has. So a little bit about history. In 1991, the video of the beating of Rodney King by the Los Angeles police officers sparked widespread public condemnation and outrage. Those officers were acquitted on state criminal charges in 1992, and that triggered riots in Los Angeles and protests around the country. Later on, I should say, two of those officers who were acquitted in state court on criminal charges were actually successfully prosecuted by the federal government and under one of those other tools of police reform, which are federal criminal charges against individual officers who kill people. But at the time when they were acquitted in state court, that sparked outrage, and there was an independent commission that was created to investigate the root causes of this, and that commission linked the beating of Mr. King to systemic institutional failures in the LAPD. And Congress held hearings on how the federal government could do more to address police misconduct. And following that set of congressional hearings, Congress passed a law that authorized the Attorney General to investigate and litigate cases that involved that pattern or practice of conduct by law enforcement agencies that violated the Constitution or federal rights. And under that authority, the Civil Rights Division can obtain a court order, like I said, requiring state or local law enforcement agencies to address those institutional failures. And we call those pattern or practice cases because, or sometimes they're referred to as 14141 cases, which is like the ultimate in federal government like jargon. 14141 refers to the section of the United States Code that codifies this authority, which is 42 USC section 14141. So we call that's what we call them, 14141 cases or pattern or practice cases. So they are litigated and resolved by the special litigation section of the Department of the Civil Rights Division in the Department of Justice. And sometimes they're often assisted actually in the investigation by local United States attorney's offices. The very first pattern or practice case ever was brought in Pittsburgh, Pennsylvania in 1997. Following a nearly year-long investigation, the division issued a letter to the city of Pittsburgh finding that there was a pattern or practice of excessive force, false arrests, improper searches and seizures, all of which were grounded in a lack of discipline systems for officers and a failure to supervise police officers. So that was one of those more kind of comprehensive, like top to tail type police investigations. And as is the typical pattern, has always been the typical pattern, the city of Pittsburgh sat down and negotiated a resolution, and they entered in a court-ordered reform agreement that was overseen by an independent monitor that was in effect from April 1997 all the way through September 2002, so over 5 years. And in fact, there was ongoing monitoring even a few years after 2002. So that gives you a sense of how long these reform agreements basically go on and on and on. So what is the process for a pattern or practice or 14141 investigation? How do they start? They can start in one of two ways. First, staff in the Civil Rights Division, in that special litigation section of the Civil Rights Division, they regularly examine information available to the division. They read newspaper articles, they read reports put out by advocacy organizations. They also get confidential information sent to them occasionally by witnesses or complainants who are complaining about patterns of police misconduct, and of their own accord, as kind of as civil service non-political appointee employees of the federal government. They review that information and using with the approval of their other civil service managers and the head of the special litigation section, who is a civil servant, and when I say civil servant, you probably know, but just to be clear, what I mean is those are employees of the federal government who remain across administrations, unlike the political appointees like me. I was a political appointee, and the leadership of the Civil Rights Division who are appointed by the president. So the civil service staff are looking at information all the time and opening what we call preliminary inquiries. And preliminary inquiries are, basically if the staff think there's something there, they think there might be a problem with the police department, they will open that preliminary inquiry. And a preliminary inquiry is not a public act. It's in fact, DOJ has fought to keep information about preliminary inquiries protected from public disclosure under what's known as the deliberative process privilege to freedom of information laws. And you might call that a debatable proposition. I wonder if maybe that's an F there, to require more information to be posted about preliminary inquiries. I mean, there are definitely upsides to not giving that information out, because it gives staff the leeway to, you know, kind of look into something without the kind of scrutiny that immediately comes as soon as there's a formal public announcement of something. But there's also downsides to that, because it's basically, you know, there's open government issues obviously associated with that. And the division has opened hundreds of preliminary inquiries since it first got authority to do this in 1994. So that's kind of an informal, non-public, kind of under the radar inquiry. If the staff in the section, that professional civil service staff, recommends that actually at the end of their preliminary inquiry, if they recommend that we should open an investigation, then that's a decision that's made by the Assistant Attorney General for Civil Rights. It's the exercise of her, or in this, at this particular moment, his authority. And the career attorneys will recommend, they'll recommend the opening of an investigation, and then the Assistant Attorney General decides whether there's sufficient cause to open one or not. And if the Assistant Attorney General decides that there is sufficient cause, that is a public act, and that gets announced. And a formal public investigation ensues. So another question that people often have is, how does DOJ decide which departments to investigate? Like, you know, obviously there are 18,000 law enforcement agencies around the country. A lot of them are broken. Arguably all of them are broken. And, you know, there will never be enough resources to actually investigate every police department that warrants an investigation. And that will be true no matter how many millions of dollars the Democrats, if they win the next election, pledge to funnel into the Civil Rights Division. There will always be a need to prioritize. And so the question is, how do you prioritize? How does the DOJ prioritize? And that, I will just tell you, is a subject of intense debate at all times, in all administrations, within the Civil Rights Division, across the Department of Justice, and in the public generally. And you know, some people think that the department should focus on high-profile cases, the Baltimores and Chicago's, generally cities, you know, big cities where the impact of racist and unconstitutional policing is the largest, at least by volume, is the largest. Other people think that DOJ should focus on emerging issues in policing that hold out the potential to set new standards. So, for example, an example that was much discussed during my time at DOJ was the issue of unlawful arrests and retaliatory force against people who were engaged in exercising their First Amendment right to record the activity of police officers in public. And you know, another example of kind of an issue that people often thought we should focus on as a kind of more niche issue was standards and practices around the use of force against people with disabilities, or people who are in a mental health crisis. So those were kind of emerging issues that it was felt that if the federal government weighed in, that it could really move the needle on developing the protections, reaffirming what the legal standards were around those issues. And, you know, there's debate about, obviously going to the big cities has its rationale, but there's also, in big cities, there tend to be other actors who are engaged in police reform. There tend to be well-developed social movements that are pushing police reform. There are often state attorney generals who are capable of doing this work. There are often NGOs like the ACLU or other organizations that engage in that kind of reform. Whereas in rural areas, sometimes that's a place where the federal government is the only game in town, like the only possible solution to systemic police misconduct. So all of those issues got debated a lot. And I think it's fair to say, and I don't think I'm spilling too many state secrets here, that there was never a real definitive answer to that. Certainly in the Obama administration when I was there, there was a dialogue about it. And we did both kinds of cases at the end of the day. And I think obviously there's a very different set of priorities around those issues in the current administration. So, so that's kind of an example. Again, I thought it might be interesting just give you a few examples of, so, you know, there's the big Baltimore and Chicago investigations, and then there are these more niche investigations. And so I just wanted to give you a few examples of those niche investigations, again, because I wonder if they might be generative of ideas for more specific targeted debate topics. But just to give you a few examples of those more niche investigations we launched, in Los Angeles County, which is the Sheriff's Department, not the LAPD, we had a reform agreement. We had an investigation that led to a reform agreement that addressed a pattern of singling out people who received federal housing subsidies for unconstitutional stops and searches and arrests, and the use of force that was linked to that. And that was based on discrimination and bias against people who were poor enough to qualify for that kind of assistance. And it was based on an assumption that people who received that kind of assistance were more likely to engage in certain types of criminal activity based solely on their status as recipients of federal housing subsidies. And so it was discriminatory. That's one example. Another example is in New Orleans. We had a finding there that the New Orleans Police Department was systematically undercounting rapes and other sex crimes because of entrenched patterns of patriarchal bias against women and not believing women. We also found in that same department, unsurprisingly and relatedly, that officers wrongly arrested transgender women for prostitution and then charged when they were just actually out on the street, and just there's this assumption that trans women were prostitutes, and they would get charged then under the state's crimes against nature law, which is this terrible overbroad Louisiana statute, and those convictions, you know, the power of prosecutors to get coerced guilty pleas for those arrests and convictions resulted in many trans women having to register as sex offenders when they'd actually done nothing wrong to begin with. Which meant they couldn't find jobs because they were on the sex offender registry. They couldn't get housing assistance because they were on the sex offender registry. And so the Divisions Reform Agreement addressed those practices and tried to get at and root out the causes of them. A final example I thought might be interesting was the investigation in Ferguson, Missouri, where the Divisions Reform Agreement there addressed municipal court practices that imposed court fines and fees on people who were unable to pay them. And then that drove a pattern of unconstitutional and discriminatory police stops and searches because the police department in Ferguson had basically been turned into a debt collection agency for the municipal government, where police would just basically, you know, randomly, I mean, it wasn't even random, it was obviously it was not random, it was intentionally discriminatory, stop Black and brown people, mostly Black people, in Ferguson on traffic stops, and then run their warrant checks through the system that determined that they actually owed a debt to the government, and then arrest them for owing the municipal court debt. And it became this, it was just basically this regressive racist tax system where I can't remember what the percentage was, but some incredible percentage, like 20-25% of the whole municipal budget was driven by municipal court fees that were landed predominantly upon Black people who could not afford to pay them and then got arrested for them. So that's kind of an example of the kinds of issues that in the more niche sense we would engage in. So what does an investigation look like? I mean, investigations, well, this is probably, I think this is actually what the meat and potatoes of the work of the department is, but I think for debate purposes probably isn't the most salient issue. So I'll kind of get through this very quickly, but suffice to say that investigations are extremely comprehensive. A DOJ team will usually spend weeks, even months on the ground, interviewing community members, reviewing documents, talking to police officers from all ranks of the department, from the leadership all the way down, including to police unions and representatives of police unions. We often consulted with policing experts on the topics that were the focus of the investigation to help analyze the information that we were taking in. People would do ride-alongs with police departments to get a sense of what the feeling, what's the dynamic of being a police officer in this place. And there was lots of data. We would collect basically almost all the data that we could get our hands on that the police department would collect. As a result, investigations often took a really long time, years. And there were lots of complaints about that because community members, you know, when a police department was in crisis, community members wanted results quickly. And the reality of a DOJ investigation is that it takes quite a long time. And that could often lead to a lot of frustration when those investigations didn't work out. Right. So what happens at the end of investigations? What happens when findings are made? Well, actually, one of three things happens at the end of an investigation: either closure of the investigation, settlement, or litigation. So first, closure. If the division determines that there actually was not a pattern or practice, which has happened, then they close the investigation. That's it. And they notify the jurisdiction that they're closing, and they make that public, that they closed the investigation. Of the 69 investigations that were undertaken between 1994 and 2017, which is the last time I had access to the data about this, the division closed 26 investigations without making a formal finding of a pattern or practice. So that's like, that's a third. I will say, and I can send you a link to a document that actually kind of goes through the timeline of this, that you will probably notice that most of those closures happened in the Bush administration, basically, between the Clinton and Obama administrations. And I think, that reflects the fact that investigations are susceptible to different political approaches that different administrations take to the validity of the pattern or practice tool of police reform. But also sometimes it just happens that DOJ opens an investigation, and by the time it ends, the police department has resolved that pattern or practice, and there's not enough evidence for the DOJ to really say, what there was a pattern here. So that actually does happen too. So that's one thing that can happen, closure. The second thing that can happen, and this is what happens in the vast majority of cases, is settlement. So the division will determine that there is a pattern or practice, and will issue that findings letter or report that sets out what the conclusions were underlying the determination. Those are public documents. They are all publicly available. Even to this day, the Trump administration has not taken any of it down or hidden any of it. It's all out there. And the findings letters will link the specific findings to specific causes. So even in the findings letter, you see the roadmap of the solutions. Like, this is what you need to do to fix this problem. Is it a problem of you have no disciplinary system for officers who commit misconduct? Is it a problem that your officers are all incredibly overworked and they're working overtime all the time and they're committing misconduct because they're very stressed? Is it because you have no policies about this, that, or the other thing? And so typically what happens is that the police department and the city or state government that's involved will then negotiate with DOJ a reform agreement that implements a specific plan to solve those problems. And in the Obama administration, at least, although I think this is, we also involved communities in negotiating our reform agreements, at least in the latter half of the Obama administration. That was one of the reflections and lessons about police reform over the course of the administration, that you couldn't just sit down, the federal government and the local government police department, and have an agreement, that the input of communities was really critically important to the legitimacy of those police reform efforts. And then, so that's usually what happened. The other thing that could happen is that the department would issue a findings letter, and the locality, the police department, would say, go jump in a lake, or something, often with much more sharp language than that, and say, well, take us to court. And so we would. And that was rare, as I mentioned. In fact, of the many, many dozens of cases where the division has issued findings letters, all but 6 have resulted in reform agreements. Of those 6, 1 went to trial where DOJ won. That was in Colorado City, Arizona, not to be confused with Colorado, but Colorado City, Arizona. We also went to trial in a case in Alamance County, North Carolina, which actually DOJ lost at trial, interestingly, but did enter into a settlement agreement while an appeal of that loss was pending. So there was, in the end, some reform there. In Maricopa County, Arizona, which some of you may know as the home of infamous Sheriff Joe Arpaio, we had to litigate there and also won. In fact, not only won the trial, but then had to take Sheriff Joe to court for contempt for failure to abide by the court-ordered agreement, and won a contempt order against him. And so that was kind of, I think there was a question in the chat, I briefly looked, I couldn't really absorb it, but people were asking, like, what do you do when they don't follow the agreement? And the answer is, when they voluntarily enter into the agreement, the truth is they follow it for the most part. I mean, it's kind of, they've agreed to this. at that point, the momentum of reform takes over. But Maricopa County is probably the best and most famous example of what happens when a sheriff or a law enforcement official is resistant all the way. And you had Sheriff Joe, and the answer was we kept going back to court again and again. And eventually, Sheriff Joe had to pay a fine out of his own pocket because the courts found him in contempt so often. But that is the only. I mean, it really is very rare that happens. And then there are a few other examples. The other two examples of the six in Meridian, Mississippi, we had to file a lawsuit, but actually the city of Meridian caved shortly after we filed the lawsuit. That same thing happened in Columbus, Ohio, where initially we issued a findings letter that initially the city of Columbus said they were not going to go negotiate agreement. Or I think that we tried to negotiate agreement, couldn't reach an agreement. And then we filed litigation, but again, shortly after filing litigation, the city of Columbus decided to basically cave. And then in Ferguson, Missouri, actually, at first, but this unfolded over a series of like short weeks. At first, Ferguson said, "We're not going to talk to you. You have to sue us." But they quickly kind of backed down, I think, when they realized what that was really going to involve. And so we did end up negotiating an agreement there. So that's kind of the big overview of this process. I want to talk a little bit about what some of the issues and controversies about pattern or practice investigations are. As I mentioned, I think this is kind of my sense of where some of the more debatey topics may come. So the first topic I wanted to flag up for you was the issue of what do these reform agreements look like, and the difference between a consent decree and a settlement agreement, a private settlement agreement. So this requires a bit of kind of obscure technocratic legal knowledge. A private settlement agreement is an agreement between the federal government and a police department that is a contract. It's nothing more than a contract. It is no different in legal terms than if you and I were to enter into a contract where you would give me you would write me, do some research for me, and I would pay you, $20 an hour or whatever. And they're enforceable only in the same way that I could enforce that contract against you or you against I. So we would go to state court, not federal court even, but state court to litigate compliance with that contract. That is not as powerful an agreement as a consent decree, which is a consent decree is a court order rather than a private contract. And so a consent decree is created when formally the Department of Justice files a complaint in federal court, but rather than litigating the case, we also immediately would file a settlement of that case, usually on the same day. But the agreement settling that case becomes a court order. So instantly violation of it becomes contempt of federal court. And also federal judges have a understood role in overseeing the implementation of those agreements, and often will appoint an independent monitor to do that, or some judges actually get actively involved in doing it themselves. And so there's much more leverage there to ensure that the police department is actually doing what the agreement tells them to do, because the federal judges will haul them into court on a regular basis if they're not doing it, and I've been involved in that many times. In fact, in my current job, working at the Legal Aid Society in New York, we have a consent decree, which has nothing to do with the federal government. It was a consent decree we won against the New York City Police Department over its stop and frisk activity, and we're going to the federal judge right now about the NYPD's replication of its patterns of racial discrimination and stop and frisk in the enforcement of social distancing rules. Just as an example, where if we didn't have that consent decree, all we could do is go to state court, which, believe me, just as a lawyer, nobody wants to go to state court. It's like nothing ever gets done, and they don't have the same kind of supervisory powers that the federal court has. Or we'd have to file a brand new lawsuit, which has all kinds of technical barriers to it. So for those reasons, in the Obama administration, there was a strong preference for consent decrees, and almost every single agreement reached in the Obama administration was a consent decree. The first thing that then Attorney General Jeff Sessions did when he came into office, the first thing with respect to the Civil Rights Division anyway, was issue a memorandum saying no more consent decrees. And that was a kind of absolute declaration of policy, that they thought consent decrees were a terrible idea. The view of the Trump administration was that that was micromanagement of state and local law enforcement, that it was disrespectful of police departments, and too much interference by federal courts and independent monitors in the operations of police departments. So that has been extremely controversial, and you can find a lot written about the difference between consent decrees and non-consent decrees, especially in media reports and academic articles that came out around the time when the Trump administration came in, because they focused on it immediately. So that's one kind of area of controversy. Another one is, and I've alluded to this, is about the monitoring teams that would be implemented as part of those reform agreements. So in the Obama administration, we put a heavy emphasis on the appointment of a monitor, or actually more often a team of monitors, to oversee the implementation of the reform agreement. And the monitoring team would be made up of policing experts who would constantly assess the performance of the police department against the benchmarks set in the reform agreements. And the selection of monitors was often a point of great contention between the Department of Justice and the local police department and the city government or municipal government, and also community members. And there were often great differences of opinion about who would make a good monitor, or what constitutes a good monitoring team. And also the role of the monitor has really been long debated in police reform circles about the effectiveness of monitors, and actually also their cost effectiveness, because the reality is the monitoring teams are very expensive, because what will typically happen is that the monitors and their teams will charge the municipal government like hourly rates, or kind of, basically they're contractors, right? And these are experts, these are national experts in police reform, and they're expensive. And so there was a lot of debate about whether that was value for money. And obviously the Obama administration really felt that it was, because the guidance of those kinds of external experts was critical to ensuring that reform stayed on track. That was the view, that was our view. But police departments and city governments often found it frustrating, because the price tag of reform was high. A third area of controversy was about how do you measure success? And I think actually, again, kind of peeking at some of the Q&As, but finding it hard to absorb the information. I think there's been some questions that get at this, like how do you know that a police department is reformed? Like, this is an existential question. And it's really interesting, because in the first generation of reform agreements, like 1994 to like 2002, basically, there was a real focus on what we would call process metrics. So this is like, has the department changed its policy, its written policy about use of force or stop and frisk, or whatever the case, whatever your target of reform is? Has there been a training program about it? Check. Checkbox, we've done a training program. Checkbox, we've changed our policy. And starting around 2012, there was a round, like in the Obama administration, of kind of introspection about whether these reform agreements were working or not. And one of the lessons that came out of that reflection is that process metrics were not actually very effective. And there was a shift away from process metrics to what we call outcome metrics. So now, to assess whether a police department is fulfilling its reform obligations, we don't ask, did you train your officers? We ask, what were the results of that training? Are there fewer discriminatory stop and frisks on the street than there were when we started? Is confidence, do community members, which we would take sometimes a survey at the outset of reform to establish a baseline, can we track that levels of confidence from community members in the police as an institution? Has it gone up, or has it gone down, or has it stagnated, or what? Is use of force rates, are use of force rates going down? Are there fewer chokeholds than there were? Whatever the focus of the actual investigation was, whatever the findings were that led to the reform agreement, have we actually changed the outcomes that are experienced by people living under this police department? And those are, that sounds simple, right? I'm sure you're saying like, duh. But those are really hard things to measure accurately. And there's a lot of debate about how you measure that. How do you accurately, how can you actually accurately tell that discrimination has gone down? I mean, it's one thing if it's kind of measuring the overall number of stop and frisks, but then like, what if the stop and frisk went down because crime went down? Like, that's a question we have in New York. Like, why did stop and frisks in New York have gone down since we litigated stop and frisk in New York. But is it because there have been systemic changes in the way the NYPD works, or is it because, you know, they're doing different things that are also racist and targeting Black and brown communities? You know, so it's a much more complicated question than you might imagine. And actually, there are a lot of people out there who would say, and there are academic papers written about this, that we don't really have great ways to measure outcomes. And as a result, the question of how do we know when these incredibly involved reform projects work and don't work, it's really hard to know. It's really hard to establish what I think you used to call solvency. So, so that's a really interesting area of debate. I also, in this part of it, wanted to just identify, and I'm sure you guys probably know this already because these are kind of obvious affirmatives, but what the kind of pending trendy reform proposals for civil rights pattern or practice investigations are. One that has always been kicking around and is also can be found in the Democrats' Justice and Policing Act 2020, which the House of Representatives has passed, but which of course will not pass the Senate, is subpoena power for the Civil Rights Division. So what is this? Despite the fact that the Civil Rights Division has the ability to investigate police departments, the statute, section 14141, does not give subpoena power to the Civil Rights Division. So what that means is the Civil Rights Division cannot compel police departments to turn over information to the Civil Rights Division as part of its investigation, which is like at some level kind of crazy. How then do we get the information? The answer is we get it because of the soft power of the federal government. Like when the federal government comes knocking on most police department doors, they can't just say, I mean, they can, but it's hard for them to say, you know, get out of here, I'm not giving you anything. And just through kind of that kind of pressure and soft power of the federal government, mostly we get everything we want. But there have been some examples where we haven't. And I mentioned earlier today, Alamance County, North Carolina, which is the one case when the federal government had to take the county to court to litigate whether it was actually engaged in a pattern or practice of unconstitutional police stop. It was mostly focused on traffic stops, racist and unfounded traffic stops by the Alamance County Police Department. And we lost that case at trial. And had we had subpoena power, I think we probably would have won that case because we had an enormous amount of difficulty getting accurate data from Alamance County because they fought every step of the way, both in the investigatory process and in the litigation process, not to turn over information that was critical to build the case. And so we had a hard time building the case and lost as a result of that. And so I think it's probably true that subpoena power in most cases doesn't make a difference because in most cases DOJ gets what it needs anyway, but in the cases that are going to get fought the hardest, which is going to be places where frankly the police departments are the most, you know, not reform minded, it could make a difference. And so that's one area where I think it could improve the efficiency and effectiveness of pattern and practice investigations. The other thing that kicks around all the time is just give them more money, give us more money so that we can do more investigations because we don't do very many and it's a drop in the bucket compared to national police reform. Again, I think, you know, obviously that's positive, but the notion that we can solve policing in America through these investigations, I think is a pipe dream because no matter how much more money you give, there will still be a limit to how many departments can be investigated. And then the other one that comes up is to shift funding to state attorney general's offices so that they can do more of these investigations. And I think the case for that is that state attorney general's offices are going to have more, in some cases, more political power and more local knowledge to build investigations that work for their state and local police departments and law enforcement agencies. And when the federal government comes in, we have a lot of work to do to understand what the local landscape is. Questions like, who are the critical community groups in this municipality that are working and thinking about police reform and that represent best the communities affected by police misconduct? What are the dynamics? What are the local political dynamics here? Does the city council or, you know, whatever the version of the city legislature or county legislature that exists in this place, are they supportive of reform or against reform? Tons of dynamics that are really essential to make police reform work that the far removed federal government has to learn new in every place, whereas there's an argument to be made that a more localized, at least state attorney general might be better equipped to address those issues. So those are some of the reform, kind of how do you reform police reform in the Civil Rights Division proposals that get kicked around very frequently. The last kind of issue and controversy I wanted to raise is really quite a big one, which is talking about the Civil Rights Division's pattern or practice investigations in the context of police abolition and the movement for defunding and abolishing police departments. And I think what I would say here is, and I say this as a person who was intimately involved with these efforts, that it's really important to understand, especially in the moment we are in, the limitations of pattern and practice investigations. The moment we are in a police reform right now is a moment of calling for defunding police and even abolition of police departments. And as those demands rise across the country, I think it throws into really stark relief the limits of the DOJ approach to police reform and the non-abolitionist lens that's applied by the powers granted to the Civil Rights Division by Congress. A pattern or practice investigation is definitively reformism as opposed to abolition. Indeed, it was my experience that pattern or practice investigations or reform agreements most often, I think probably in almost every case that I was involved in, resulted in fairly significant increases in funding to police departments. And that was true, in the Obama administration. And I think, and I'll get to this in a minute, that's even more true, that federal reform generally, I mean, there haven't been many pattern or practice investigations in the Trump administration. There's been one, in fact, one new one the entire time. But, so it's hard to draw any conclusions about it, but instead they've shifted to other forms of federal intervention and policing that, again, mostly just drive resources and push resources from the federal government into police departments. And so it's really important to understand that that's the framework and lens of a pattern or practice investigation. And, I think if you were, I think it'd be very ripe, I think if you're going to run, if you, for example, were going to run an AF that's about increasing or relying on pattern or practice investigations, you could really expect a kind of critique from an abolitionist lens. And I think that would be something you'd really have to engage with. And it's also important to understand what DOJ is, after all, right? I mean, why is the police reform lens in the federal government non-abolitionist and very reformist? You have to remember, and I could tell you many war stories about this, that the Department of Justice is a building full of prosecutors. The Civil Rights Division, even the Civil Rights Division has a lot of prosecutors in it. But the Civil Rights Division is the only place that someone with a background like mine, as an activist outside the system, would ever, find space, basically. And we are one small division in a very large building that is mostly led and controlled by prosecutors. And so, and also, it's also a building, by the way, that houses federal law enforcement. So in the Civil Rights Division, you can't undertake an investigation, or you have to be aware of the degree to which an investigation you undertake into a local police department might reflect on the FBI and its practices, because they're your colleagues. And if the FBI uses a policing tactic, and you can't, the federal government can't be, it's a left-hand, right-hand thing, right? The Civil Rights Division can't be criticizing local law enforcement for something that federal law enforcement does. And that is a dynamic that is institutionalized. That's always going to be there. So basically what you think about the Civil Rights Division really depends on what you think about reform versus abolition, and whether you think reform or harm reduction, as some of us have started to call it, has a place, or whether you think actually that reformism has been a barrier to the more necessary or kind of root and branch reform of a police reform of abolition. Okay, so last thing I wanted to do, and this will just be a few minutes and then we'll be done and just do questions, is just briefly go over and identify some of the other tools for police reform that exist in the Department of Justice. And there's 3 of them that I wanted to point out. One is criminal civil rights prosecutions. This is the Civil Rights Division and the Attorney Generals, not the Attorney Generals, the Civil Rights Division and the United States attorneys in each state have authority to criminally prosecute any law enforcement officer who willfully deprives a person of a constitutional or federal right or engages in a conspiracy to do that. And this is a very different tool to pattern and practice investigations. This, whereas pattern and practice cases are focused on systemic reform, on the law enforcement agencies, policies, and practices, this is about one officer and what he or she did in a moment, and that officer's own culpability for what happened. So, whereas the pattern or practice cases end up with these giant reform agreements with a wide range of reforms that get implemented over time under the supervision of the court and a monitor, a criminal civil rights prosecution seeks to convict and sentence to jail an officer in order to punish that officer and deter individual wrongdoing by police officers. In many cases, these things go hand in hand. Many of the biggest pattern and practice investigations also had parallel prosecutions of individual officers. Like in Chicago, there was they didn't end up doing it because these things actually really rarely happen, which I'll explain in a minute, but they were investigating, there was an investigation on whether to prosecute the officers who shot Laquan McDonald in 2015 or 16, alongside the Chicago Police Department investigation. Likewise, in Baltimore, when Freddie Gray was murdered, there was, again, they didn't do it, but there was a discussion about prosecuting the officers who drove Freddie Gray around in a van until they broke his back, alongside opening up an investigation to the broader problems in the Baltimore Police Department. But they're very different approaches, as you can imagine. And they're really hard cases to bring. The legal standard is almost impossibly high. And that's why so often people found themselves very disappointed when even more progressive attorneys general like Eric Holder and Loretta Lynch in the Obama administration did not bring prosecutions against individual officers involved in high-profile instances of police killings. And it wasn't because they didn't want to, mostly. It was because the legal standard is so high. So to prosecute an officer, you have to prove beyond a reasonable doubt, because that's the criminal standard, that the officer's actions, such as shooting a person or using force, putting their knee on someone's neck or whatever it is, was objectively unreasonable based on all the surrounding circumstances, and that they acted willfully, and that they had the specific intent to do something that they knew the law forbade. So it's not enough to show that an officer made a mistake or acted negligently or even exercised bad judgment, and all of it just becomes very difficult to prove all these things. So as a result, basically, very few of these prosecutions happen, and even when they happen, they are often lost. And that can be really demoralizing, and so the department is very wary of bringing cases that it thinks it's going to lose, because bringing a case and losing it often causes more harm, especially to the families of victims, than not bringing a case at all. And there's a real consciousness of that inside the Department of Justice. So one of the other reforms that gets bandied around, and again, this is also reflected in the Democrats' Justice and Policing Act that they just introduced and I think passed. I'm not making that up, right? Maybe, yeah. I'm sure they will pass it if they haven't, but it won't pass the Senate. Is changing the legal standard applicable to these criminal prosecutions to make it easier to bring them. So the reforms in the Justice and Policing Act would lower the intent standard, what we call the mens rea standard in the law, from willful to knowingly or recklessly. And it would also clarify that it doesn't have to be, one of the other legal hurdles is that you have to establish that the person's death was definitively caused by the actions of the officer in order to make them liable for the most severe charge of causing someone's death. And that can be really hard. I don't know if you noticed, there was a lot of controversy about even George Floyd, and initially the medical examiner did not issue a finding that it was the strangulation by this officer that caused George Floyd's death. That finding, which I think has since been challenged and maybe rolled back, would be the death knell for a federal prosecution of that officer, Grimes. And so that's why those kinds of findings are so important. So that's one tool, is those prosecutions. The second tool, the last two tools I wanted to go over very briefly, are really more about money and financial support and kind of soft power in a way, kind of. So there are two different entities in DOJ that basically provide technical assistance to police departments. One is called the Office of Justice Programs within the Bureau of Justice Assistance. There's some bureaucratic terminology for you, of the Department of Justice. And they do training and provide technology support and also cash to police departments to support specific goals. So they will do, and they do hands-on trainings to kind of teach departments how to do new things. And they will, in the Obama administration, we actually used these grants to try to support what we used to call constitutional and effective policing, which is, you know, we would do grants that were targeted at how do you get police departments to take rape accusations more seriously, or violence against women, you know, domestic violence situations, so that there was less gender discrimination in law enforcement, or how do you train officers in de-escalation techniques, or in how you better encounter people who are in mental health crisis. So things that were kind of about trying to not just help them fight crime, but to help them reduce civil rights violations. And then the third one, similar to that, is what's called the COPS office, COPS, which is stands for Community Oriented Policing. I can't remember what the S stands for anymore. Sorry, COPS, the COPS division of the Department of Justice. You can Google it. And they have a tool they call collaborative reform. And my sense from looking at what the Trump administration has done is that this tool has largely devolved into just more technical assistance, similar to what OJP does. But in the Obama administration, there was a lot of effort to take departments that had systemic problems that weren't quite so severe to warrant a pattern of practice investigation, and instead of investigating them in this kind of litigious way that we did in the Civil Rights Division, to kind of hold their hand a little bit more and get them, you know, to reform on their own, to kind of support them to implement reforms. And it would look a lot like actually the implementation of a reform agreement that we would do in our pattern of practice investigations, but they would just, it would just be more collaborative. And so that would be in a department that actually, sometimes departments would come to DOJ and say, look, we've got a problem. And that happened, for example, actually in Minneapolis. So maybe that tells you how effective this tool was. Just say not especially effective. But the Minneapolis Police Department at some point did kind of realize it had a problem, and this was in like 2016, and came to COPS. It was like, look, we need some support to help out here, and COPS went in and kind of helped it design its own reform agreement. And maybe it was successful, and actually maybe they stopped doing it in the last several years, and that's why Minneapolis took the turn it did. I don't know. We'd have to get an academic to study that question, but you know, I have my guesses. But that's another example of police reform. So that's really, on the whole, the kind of, those are the federal government's real major tools for actual police reform. And kind of the end also of the lecture part of this. So really happy to take questions at this stage. I know there's some questions in the Q&A, but Kevin, I don't know, do you want to field them, or do you want to?
Yeah, sure. We'll just kind of go through a few of them there. Thanks for that. And for anyone watching, feel free to add something else to the Q&A.
And I'm also happy to take questions. I mean, I might not be able to answer all of them, but if you have questions that, are a little bit off topic too, that's okay.
Yeah. So I know you kind of went over in depth, you even kind of referenced the chat a couple of times during that lecture during this about reform compliance and stuff like that. I guess in your assessment, do these reforms tend to be lasting? I know you said it's really difficult to, determine that objectively. There's no like quantitative metric for it, but are there examples of after monitoring team or judge monitoring is over, do the police agencies just return to their old practices, or do they really do seem to be, because of the momentum, like you said, solvent?
Yeah, so can everyone access the chat?
Yeah.
Okay, so I'm gonna throw up a link in the chat to a document that kind of gets at that question. I actually wrote this document when I worked in the Obama administration, and it's a overview. I mean, you can read it. I mean, a lot of my lecture, it looks a lot like this lecture because I wrote it. And in that document, there are some links to academic studies of DOJ's pattern of practice investigations and assessments of their effectiveness. And you can see in that document, there have been a few studies. One was by the Vera Institute, which is a big think tank that does criminal justice work. There was a study by Chris Stone and when he was at the Harvard Kennedy School, and those two reports assessed specific agreements were comprehensive reviews of pattern and practice investigations that had then closed. I think the Kennedy School one was of the Los Angeles Police Department agreement, and the Vera one was, I think, of the Pittsburgh agreement, but I can't remember now, but you'll find it in that document. And both of those, they have criticisms, and actually the Obama administration changed its practices in response to those studies and what they revealed about what worked and didn't work. But overall, they concluded that actually these reform agreements were effective. I think it's important to say, again, especially in the moment that we're in right now, that effectiveness in that, in this sense, is really defined in terms of, is the police department a little bit less horrible than it used to be? I don't think anybody could look you in the eye and say that any of these places that the DOJ has investigated are model police departments or don't have problems. So that question of the effectiveness of this and whether police reform can be achieved with this tool is, I think, a really open and interesting question. And my personal opinion is that in a world in which police departments are going to exist and therefore need to be reformed, this is an important tool. It's not a perfect tool. It's not going to solve all the problems. It's definitely no panacea. We have to be clear-eyed about its limitations, but it does work. And in fact, it's one of the only tools that really does work. And it's a real shame when I think administrations come in and kind of abandon it as a tool, as really has happened in the Trump administration. But I also think, again, I think there are limits to what can be done.
Can the Department of Justice sue under Title IX of the Civil Rights Act to get departments to reform?
No, because law enforcement agencies aren't covered by Title IX. They are covered by Title VI and by the Constitution. So there are, because Title IX is an education statute, it covers educational institutions. But discrimination, the prohibition on discrimination that is embodied in Title IX is embodied, those same prohibitions of discrimination are contained in other parts of federal law as applied to law enforcement. So just as the Department of Education can investigate universities or schools under Title IX for discriminatory practices, whether on the basis of sexual orientation or sex, or gender identity, or race, or national origin, there are federal statutes that do apply to law enforcement that prohibit those things, and also the 14th Amendment to the Constitution.
Can all the mechanisms for reform, or perhaps some of them, be applied to things other than local police departments? So like the DEA or U.S. Marshals, is there like a way to internally reform those?
Not through the Civil Rights Division. So the way that if the only way, so if you want to target a federal law enforcement agency, any of them, the Marshal Service, DEA, FBI, anybody, that you've got, I think, basically two options. One is to sue, to litigate, just like file a lawsuit on behalf of some individuals, which is what I do for a living now, and I did when I was at ACLU as well. The other thing is what the federal government can do is that each federal agency has an internal, like, Office of Civil Rights type agency. So DHS has one. I guess in the FBI it would be DOJ. Who would investigate the FBI? I have to think about that. But they do investigations. Even in the Obama administration, when we were the most aggressive about police reform that I've ever seen us, I would not have described those offices in any federal agency as particularly robust. Now, of course, in debate, you have fiat power, so you can make them more robust and make them actually investigate themselves and do better about implementing reforms. But on the whole, I think those internal oversight aspects of those agencies are not particularly effective.
Yeah, that makes sense. Does the Department of Justice have a way to get around qualified immunity?
Yes, the Department of Justice doesn't have to deal with qualified immunity because the Department of Justice doesn't sue for money damages, right, ever. Like all the Department of Justice does is try to get what lawyers call injunctive relief, which is say ordering reforms. Qualified immunity is only a defense that belongs to individual police officers who are sued for money damages by people who are victims of their police misconduct. So it just doesn't arise as a barrier to what the DOJ wants to do, which is great because, you know, the reason qualified immunity is bad is because to establish that an officer did something wrong, if I'm a victim of police misconduct, to establish the liability of that individual police officer, I had to show that the law was clearly, that what they did was clearly established to have been illegal at the time they did it. And that's just really hard to do because cities and police officers have gotten really good at parsing the law to make it just like a little bit ambiguous that under these circumstances what they did was actually illegal. And the Supreme Court has been very permissive in terms of letting them do that. But none of that even comes into play when you're talking about the DOJ's investigation of just, are these patterns and practices, does it violate the law or not violate the law, like objectively. You don't have to deal with, is it clearly established? None of that comes into play. So it's a nice way around that.
For a couple of off-topic questions briefly, for a student interested in going down the same legal and professional pathway as you have, what are some tips or recommendations that you think might be important to know ahead of time? What things can we get involved with both in high school or in college to go down a similar route?
Yeah, well, I always like to discount any advice I give by saying that like times have changed, and I'm not really sure I would be where I am now if I had to deal with the environment in which you guys operate, which I know is like a depressing thing to say, but it's just kind of an honest thing to say. I think I've been really lucky. But I think you're on the right track because I do think that I am where I am today because of debate. And debate got me here. I think debate got me into law school. I know that it did. I think debate teaches you critical thinking skills that will put you way ahead of the vast majority of people. The work ethic and ability to research that just like is unparalleled. And also, you know, the debate community is full, like the debaters are everywhere. I mean, I can't even tell you how many times I look around in the work that I do now and it's like, oh, I know that person from debate, or someone will say, oh, that person was a debater like 4 years after you and you didn't know them, but like now I'm like, oh, a debater, I like that person, you know. And I benefited from that as a when I was younger too, of like other people who had been debaters knowing that I was a debater and automatically thinking I must be okay because I was a debater. And so I think debate is an incredibly helpful thing. The other thing I would just say is if you're kind of on the law school path and on this path of wanting to be a movement lawyer, which I consider myself to be, that it's really important that you fortify yourself to do that, because law school in general tends to push people into corporate law. Most law schools do. And the overwhelming culture of law school, and law school is so expensive, I mean, there's all these pressures on you to, it was really hard, you know, even for me who wanted to go to law school to be a movement lawyer, to then like forego the opportunity to earn a lot more money than I earned, you know, have ever earned, basically. So, and sometimes I still think about that. I'm like, oh God, what did I do? But I'm very happy. So, you know, I think just kind of making sure that that's really what you want to do, and knowing that you will be against the grain of the culture in law school, and being ready for that, and committed to it if that's really what you want to do, and then doing things in law school that demonstrate that. So in law school, there are opportunities to participate in what we call clinics, which give you hands-on experience being a civil rights and movement lawyer, and doing those is really important and helps you break into what is actually, you know, a very difficult career path to break into, because you know, there aren't that many jobs, basically, is that, you know, whereas there's lots of jobs if you want to be, you know, a corporate lawyer.
Kind of a bold question. Do you support reform or abolition?
Yeah, I really struggle with this as a person. I would call myself abolition curious. I certainly have been on a journey with this, and as my career path kind of reveals, you know, I obviously was like in the belly of the reformist beast for a while, and but I also, because I was there, I really do very clearly see the limits of reform, as you kind of maybe got a sense of in the way I was talking about it in the lecture. And I think, I think I'm definitely a defunder. I have been very supportive of efforts in New York City, which is where I live right now and where I focus most of my activism on the efforts to defund the NYPD by $1 billion instantly, which we did not win, sadly. The budget that got passed in New York City these past couple of weeks was a facade of cutting $1 billion out of the NYPD, really just shifting some money around and having some fuzzy math. And that's a shame. I think it's absolutely unequivocally critical that we get police departments out of a lot of the actions that they're involved in. And we've made enormous mistakes as a society in defaulting to law enforcement-led solutions to social problems and over-investing in police departments at the expense of much-needed social and economic, investing in communities, basically. I mean, that seems to me completely uncontroversial. So, but abolition is more than that. Abolition is abolition, as Mariana Yukawa would say if she were here. And I think I'm actually in the middle of doing, this is I work with a lot of abolitionists, and I've been challenged by a lot of my colleagues to think more critically about abolition, and so I'm doing that. I'm actually reading Alex Vitale's book as we speak. It's on my nightstand in the other room, and I'm thinking about it. But I have a lot of questions. I think a lot of questions a lot of people have about how do we deal. The answer that what does a world without policing looks like as a suburb, I find singularly unimpressive as an answer. I grew up in a white suburb, and what that looks like is privatized policing. In the white suburb I grew up in, white neighborhoods that were richer than my poor white neighborhood used private security to keep even people like me out, let alone all the Black people who live south of 8 Mile Road in the suburbs of Detroit. So I worry that the abolition of policing will just reformulate power in a way that will be much worse, actually, than the public function of policing is. But there are people I respect who think I'm wrong about that, and so I'm kind of trying to figure it out.
And I tend to agree with that as well. But thank you for that thorough answer. A few more reform questions. Do you think that there could be any sort of reform that could make the investigation process faster? And just kind of adding to this question, I would say, especially given like the creative powers allowed to plan writing via fiat, if you could, how would you choose to expedite or improve the process?
Yeah, so I'm a little bit wary about calls to expedite civil rights investigations, because what the people who do the investigations would tell me time and time again when we were facing pressure to speed them up is, if you want to do it well, and it takes as long as it takes. And I think, as with all things, like all things we all do in life, that is probably 60% true, or maybe 65% true, and 35% like you probably could do it a bit faster. And so I think it probably could get speeded up in a certain way. And I do think that more resources would always help. There were times in the Obama administration where, there was a time, for example, this gets into the kind of real, this is kind of boring, but so I won't do too much in this, but like when we opened Baltimore and Chicago within a couple months of each other, and we didn't have enough investigators to like send them out onto the ground immediately in both places. Like we just didn't have enough because those were two huge investigations to be running simultaneously. But the country, this is 2016, the country was exploding. This, again, like it is now. And we had to open both those investigations. And so, more resources probably would have made both of those go faster. It's also really interesting that, this is a little bit spilling political gossip, but I don't think anybody wouldn't have noticed that the Baltimore and Chicago investigations were both closed before January 2017, even though they've been open not that long before, and they went much faster than other similarly sized investigations. And the reason for that is really no mystery. And so when the fire, when with the deadline, they got faster. Now there were also things that we wanted to do. In particular, I was much more involved on the ground in Baltimore than I was in Chicago, and there were things we wanted to do. There was some data analysis that we didn't end up doing in Baltimore, because we ran out of time, that I think we would have done if we had more time. So it's a bit like, okay, well, should it have been faster or should it have been better? And the tension there. So I think the reality is there's not that much you can do to speed these things up because they are complex.
That makes sense. Can you explain the utility of the 1033 program, both the pros and the cons from the perspective of the DOJ?
The 1033, that's the military assistance program, right? Yeah. Yeah, I mean, look, when you say the perspective of the DOJ, let me be very clear. I only ever had the perspective of the Civil Rights Division of the DOJ, which is a very niche perspective of the DOJ. I'm sure there are aspects there, what we used to call in the building stakeholders in the DOJ who would defend the 1033 program. From my perspective, and I think it's probably fair to say from the perspective of me in the Civil Rights Division in the Obama administration, that program was a disaster from front to beginning. It was completely unjustified. When we saw tanks rolling through the city of Ferguson, Missouri, outside of St. Louis in 2015, like why that program was allowed to persist at all from that point forward is a travesty. So I think it should be banned. You probably know that's the Democrats' Justice and Policing Act doesn't even ban it. It actually just further curtails it, which I don't really understand where the constituency for this is outside of the military itself, which must get some kind of money for selling these surplus goods, and obviously the police department's pushing for it. But I don't. Yeah, it's a mystery to me why this is allowed to happen. It's crazy.
Yeah, it is. A little off topic, but this is about strict liability. Are certain crimes designated as strict liability crimes, or is it only applied to them on a case-by-case basis?
As a general matter of criminal law, there exists a thing called a strict liability crime, usually in the context of corporate crimes. They're very rare. I can't think of any example when it comes to what we call common criminal law that police officers enforce, or to the criminal laws applicable to police officers, where there's a strict liability crime. Most crimes require, the vast majority of crimes, almost all crimes, require some element of intent to have done the act that was the criminal act, what they call mens rea. So not a strict liability crime in that sense. Is that what she meant? Is that what was meant by this question, or have I kind of missed the?
I think so. That was all they said. So if you ask that one, feel free to clarify in the chat if there's anything additional you want. Would you say that the pattern of practice litigation methods form a better legal precedent than independently prosecuting officers?
Yes, I would say that. In that document that I threw up, in some of the documents that are cited in that document, you will see that there is some evidence from academic studies of DOJ's pattern of practice investigations that the conclusions reached in the findings letters have had effects on police standards nationally. So, and this was often the argument I referenced when thinking about how to prioritize investigations, that there was evidence that if DOJ came out and said, when you do this policing practice, it is unlawful for this reason. For example, the example of when you arrest people who are filming police officers, that violates the First Amendment. That actually helps set a new standard for policing across the country. It draws attention to that issue. It puts other departments across the country on notice that if they're doing that, they might be vulnerable to being investigated by DOJ, which most police departments really would rather avoid that outcome. And so it does set a precedent. And I guess in thinking about solvency issues for an affirmative that was about DOJ, I think it's really important to understand that there is good evidence that an investigation into a police department doesn't just solve a problem in that police department, but does have this spill on national effect, where it can kind of, both by deterrence and by example, promote better standards of policing across the country. So I think that has a big effect. I think when it comes to individual officer misconduct, that there's very little evidence that prosecutions have much of an effect on individual officer behavior. I don't know of any evidence that actually does, much like there's very little evidence that criminal prosecutions in general could deter crime. There's some evidence that certainty of, actually, and it's really interesting, in the deterrence literature, which some of you may have researched for this or other topics, there's really no evidence that punishment levels deter crime, right? There is some evidence that certainty of punishment helps deter crime. So if you have a sense that that you are likely to be held accountable in some way, and or more or less have some sense that you are less likely to be accountable, you're more likely to do it. But whether you're punished by 5 years or 10 years or 15 years in prison, like, doesn't seem to make much of a difference. So there's no evidence that it does anything, basically. So, and I think that's really interesting when it comes to criminal prosecutions of police officers, because they are so rare. And officers know that. I mean, even we couldn't prosecute the guys who killed Freddie Gray. We couldn't prosecute the officer who killed Eric Garner. And that was in an administration that wanted to exercise this tool, and it wasn't done. And those officers know that. And so I just don't think there's really any evidence or any reason to believe that, at least as currently situated, you know, maybe if they reduced the legal standard and suddenly there were a lot more criminal prosecutions, maybe that would, of officers who engage in misconduct, maybe that would be different. But I don't see that.
So what books would you recommend researching for this topic? And generally, you're asked to give some tips on research.
Yeah, there's not a lot of books written on this particular topic I've been talking to you about DOJ investigations. But there is, again, I think that document I sent around has a bibliography in it that, at least as when I wrote it in January 2017, again, gotta out under the line. That's pretty comprehensively all the research that there really was on pattern and practice investigations. There may have been some things published since then. I have to say I haven't really kept up on the research on the specific topic since then. And, you know, journals, criminology journals, there are a lot of academics who do study this. A couple authors I know who probably do, who have written on this. Include a guy named Michael White from the University of Arizona, who has done a lot of research into DOJ police reform efforts. Christy Lopez from Georgetown, who actually used to work for me she was the deputy chief of the special litigation section that ran policing investigations, and she was the lead lawyer on the Chicago investigation. And is now left the administration, or left the Civil Rights Division, and works at Georgetown. There's really, to be honest with you, she's like the #1 expert on the subject as far as I'm concerned in the whole country. And she may have written a bit about this. If you can get in touch with her, also, she's a lovely person and actually probably knows, could give you more research suggestions about this, because I'm not an academic anymore, but she is an academic. Other people who have written about this. Yeah, it's not a huge literature on this subject, actually. But yeah, but that document is a good place to start, and I think those other folks are a good place to start too.
You covered this one a little bit, but I guess with subpoena power, how much more successful do you think you would have been in the Civil Rights Division?
Yeah, I think so. I kind of hinted at this before, but I would put it this way. I think in a big investigation, in the vast majority of investigations, I don't really think subpoena power makes that much difference, because in practice, DOJ gets what it needs. But in the rare case where we have a recalcitrant jurisdiction, which again tended to happen in places that were a bit, not big cities where there are political pressures on police departments to kind of cooperate, right? Like, imagine Baltimore, Chicago, right? The mayors of Baltimore and Chicago are not going to be able to put up, they're not going to be able to absorb the political blowback they get from their local newspapers if it was found out they were blocking a DOJ policing investigation. But the sheriff of Alamance County, North Carolina, Sheriff Joe, it's the opposite, right? They love the headlines that they got when the headline was Sheriff Joe gives the finger to the federal government, right? That was positive politics for them. So where I think subpoena power would make a difference is in the investigations of places where the politics make it possible and likely that a local law enforcement agency is going to put up a fight and not cooperate with an investigation. Does that make sense? So it would make a difference. but not in the majority of cases it doesn't. But in the hardest fought cases it does. So I know it wouldn't make it's like volume wise, it doesn't make it big picture wise. I think it's not a huge difference, but then in some really critical cases, which are important cases, often cases where, I mean, I'll put it this way, really important because the same dynamics that make it possible for a local law enforcement agency to be so recalcitrant and get away with it, and the politics actually encourage it, are the same places where there is no other system of accountability but the federal government parachuting. Because those political dynamics that make it so it's popular for this sheriff to be behaving that way are the same dynamics that drive the problems, and also dynamics that undermine local efforts at reform.
Kind of a niche question. Do you have any good resources for definitions, and where does the Department of Justice get their definitions when they cite them in legal cases?
Oh, well, that's an interesting question. You mean like for topicality?
Yes.
Oh gosh,
I presume.
I haven't even like thought in these terms for like 25 years, you guys. I mean, the truth is, we don't think about definitions, right? Like, no, that much. Gosh, I
think because I'm guessing with this question, because most T, or at least a lot of T evidence comes from court cases where there was a dispute over a word and like both sides are making some kind of case for why the term applies. I think perhaps people think that maybe definitions come up more often in lawsuits and constitutional law, especially, than maybe they do.
Yeah, but not, I think, of the words that are in this topic. Like, there's intense debate about what's the definition of excessive force, for example, right? Or, false arrest, or kind of like, those key legal terms. That's for sure. But I'm thinking back to what you said the topic was. I can't think of a word in the topic that kind of has that same real world debate about a definition that would come into play. Yeah, it's tough. I'm sorry, I'm not very helpful.
That's all right. Do you think that, and I guess like either presumably for a future Democratic administration or even for the current one with this question, do you think that the recent wave of police killings and protests to them will spark more pattern practice investigations? And why hasn't it already in, I guess, the current DOJ?
No, I don't think it will, because I think this administration is indifferent at best and hostile possibly to pattern or practice investigations. They have opened one. I can't remember now. One in Florida, I think. It'll be on the Civil Rights Division website. And I should have looked it up. I'm sorry, before this thing, guys. But they've only opened one investigation in the past, 4 years, and you have to understand too, like, it won't be for lack of the employees of the Civil Rights Division trying. The people who work, especially the first few years, I'm sure, there have been new hires and they will probably be a bit different. But there are a lot of people in the Civil Rights Division who are career employees of the Department of Justice and who have worked there. Many of them worked there through, the Bush administration, through the Clinton administration, through the Bush administration, there's people who have just been there up and down, and they're just not political people the way that, like, I am. Like, I mean, there's no way I would get hired, right? But, and they like put their heads down and they do their job. And there will, and these will be people who even kind of are, call it, to the extent that they're like Republicans, right? But like, probably never Trump Republicans, I guess, I don't know. But, and they'll be trying, and they haven't succeeded in opening any more than one investigation into, I can't remember where it was, but it was not a particularly high profile place, right? So there is no momentum right now in this division to open up policing investigations. I suspect strongly that the division, the career civil servants, the career employees, are using all the political capital that they have to protect the open reform agreements that they're monitoring now from political interference, and to make sure they stay on track. And they don't have much political capital to spare to convince this administration to open new investigations when it's very, very clear that they don't want to. And I don't think anything about the politics this moment is going to change that, because I don't think, while I think there's really are transformative politics happening right now, I don't really see any evidence that the transformative politics are reaching this administration.
Yeah, that makes sense. I guess concluding thoughts. I'll just try to summarize a few different questions together, and we'll have a few we're not going to get to, sadly. Concluding thoughts, recommending applying the policing field to a successful affirmative, one that the state couldn't solve, one that had a pretty decent chance at winning that it solved, even in the face of all of the likely pushback and inability to succeed that you kind of referenced throughout your lecture.
You mean the question's like, what are some good AFs? Is that what you're asking?
Yeah.
Yeah, I mean, I think subpoena power is a good one. You know, it strikes me as like, you know, again, I don't want to overstate. It wouldn't be like a revolution in policing, but it would be a really positive step. It would do some good, and I'm not sure what's controversial about it. You know, it might raise some costs for some. No, I mean, if anything, actually, it would probably reduce costs because, you know, the alternative is you spend a bunch of time and resources fighting about getting documents, and probably DOJ is going to get them in the end anyway. Or it's not going to, like in North Carolina, and then we lose cases we should have won. So I think that's a nice one. I think, you know, I think it would be a controversial one, a bit of there'll be some trench warfare about this, but the reforms that are proposed to lowering the legal standard for prosecuting federal criminal prosecutions of law enforcement officers is also one. I think, you know, there's a big debate. It was a bit like this isn't anymore. Probably climate change debates aren't, but like climate change was like the trench warfare issue of like my debate life. We had two topics where climate change was an F in my debate career. And it was like, you know, some people just really wanted to get into it, you know, like let's just go to the trench. We're going to win every time. You know, I think this would be a bit like that because it's controversial. Like the whole idea of it is controversial. And, you know, as a framework issue, like, should we even be doing these prosecutions? Do they even work? But if you win that, there's no, and if you can defend that this is a good tool of accountability, which, you know, again, and there is an abolitionist argument for the, you know, it's really interesting. Okay, so I'm jumping around a little bit. Let me just finish my first thought before I talk about the abolition thing. If you can win that prosecuting individual police officers is a good idea, then I think it's unequivocally true that the reforms that are proposed in the Justice and Policing Act, and maybe even some additional ones to lower the standard, make them easier, are good ideas, because it is absolutely true that these cases were impossible to bring, and it was incredibly frustrating for those who wanted to bring them. Okay, and now I will say, you know, whereas I think if you're going to any case that you might run that involves improving or reforming or advancing or making more pattern practice investigations, I think it's going to be very susceptible to an abolitionist critique. There's actually the criminal prosecutions is actually, I think, an abolitionist take, because getting police officers individual officers who commit misconduct criminally charged is going to get them fired, and it's going to reduce the size of police departments and especially one of the challenges of real world abolition is you can have, like, and we experienced this in New York, you know, this month, where police union rules are a huge barrier to abolition and to reducing the size of police departments, because what it means, if you were going to, the name of the game in abolition is reducing headcount for police departments, and because of police union contracts, the only real viable way to reduce headcount is a last in, first out rule. So, or also attrition. So in New York, for example, the little modest progress we made was to reduce, there's only going to be one incoming class of police officers next year, as opposed to usually there's 3. So there won't be any new officers added as a way of reducing headcount, because the NYPD is so big that there's kind of people always leaving. Anyway, what I'm trying to say is, adding new officers are not the problem. The problem, the worst problem, are the ones who've been there for 25 years with 300 police misconduct complaints against them, that the union is defending them every time, and the disciplinary system is broken, and there's no accountability for those officers, and they are poisonous, and they are spreading bad culture within police departments, and they're getting away with it. And you cannot remove those people because of union rules. And it's just incredibly difficult as a practical matter to get at the worst officers. So even abolition, you know, in its kind of easiest path forward is going to involve shrinking police departments by not adding new officers, which actually leaves a rump of like the worst officers, basically the officers are most enmeshed in a bad culture police department. Whereas get them fired, because of misconduct, and you're kind of eating away at the beast from the other end, from the really bad end. And so that is abolition.
Gosh, that's a great argument. So that's all we have time for. Thanks a lot. This was awesome. It was so cool to like hear from somebody who's done and worked so hard, not only on the topic, but kind of from the background that kind of all these students are developing as well. So this was great. Thank you so much.
Great. Good luck, guys.